Namaskar. Welcome to a new episode of Bharatiya Nyaya Sanhita 2023. Today we are continuing with the discussions of definitions given in the statute such as illegal, legally bound to do, judge, life, etc. Section 215 of Bharatiya Nyaya Sanhita 2023. Illegal and legally bound to do. The word illegal is applicable to everything which is an offense or which is prohibited by law or which furnishes ground for a civil action, and a person is said to be legally bound to do whatever it is illegal in him to omit. The corresponding provision is section 43 of the Indian Penal Code. Section 43, illegal or legally bound to do. The word illegal is applicable to everything which is an offense or which is prohibited by law or which furnishes ground for a civil action, and a person is said to be legally bound to do whatever it is illegal in him to omit. Section 215 says illegal and legally bound to do. What is meant by illegal? This can be understood in two different ways. The first one is commission of an offense is illegal. So anything that is an offense is defined to be illegal. Then the question arises, what is offense? Anything defined as an offense for which or for the violation of which amounts to conviction and punishment, that is an offense. So if an act is said to be or defined to be an offense and the violation of which is followed by punishment or sentence, then that is known as an offense. Further, if an act is defined to be an offense and if it were not defined as an offense, even though it may not be moral, it may not be proper in common parlance, still it will not amount to an offense. So that is the protection given under the Constitution of India as a fundamental right. So if an act, unless it is defined to be an offense, even though it may not be moral, even though it may not be proper in the common parlance, still it will not amount to an offense. So first of all, in order to make an offense, an act to be an offense, it must be defined as an offense by a statute like Indian Penal Code, Bharatiya Nyaya Sanhita, or Narcotic Drugs and Psychotropic Substance Act, Prevention of Corruption Act, Dowry Prohibition Act, Protection of Children from Sexual Offence Act, and things like that. Act is defined to be an offense, then it is illegal. And the second term, illegal. Suppose if a person violates a law which is not defined as an offense, still it is illegal. Means it provides legal consequence in civil law. For example, if a person borrows some amount from another and with the intention to repay it, it is not a gift, then, and if that amount, that person does not repay the amount, that is illegal. So anything violates the law, even though it provides civil law action, then that is also illegal. Giving or doing something which prohibits civil law, then that is also illegal. Then the next term is legally bound to do. What is meant by that? Legally bound to do means if a person duty bound to do something and if he omits to do that, then the term legally bound to do comes. Normally, in order to become an act to be offense or illegal which invites civil consequence, there should be something actionable, something positive, something active must be done. In legally bound to do, there is nothing active. A person is inactive. Only because of he is inactive, legal consequence follows. A jailer or a school headmaster or a college principal or a presiding officer of a court or a superintendent of an office or a bank manager or a zonal head or a president or a vice president or a secretary, whoever in power, and if it were a duty on his part, a bank manager has to take care of the entire currency or other valuable security and the assets in the bank. And so assume for a moment the bank manager does not close the bank in the evening, and if he just keeps it open, then this comes. He was legally bound to do, which he omitted to do. So bank manager has to close the bank and shut the door and lock it in the evening as soon as the bank hours are over. And if that were not done, then this comes. He was legally bound to do, but he omitted to do. So illegal and legally bound to do, one is active, other one is passive. So these 3 points must be kept in mind while understanding the provisions in the Bharatiya Nyaya Sanhita. But one is active, other one is passive. 216 of the Bharatiya Nyaya Sanhita. Judge. Judge means a person who is officially designated as a judge and includes a person, 1, who is empowered by law to give in any legal proceedings, civil or criminal, a definitive judgment or a judgment which, if not appealed against, would be definitive, or a judgment which, if confirmed by some other authority, would be definitive, or 2, who is one of a body of persons, which body of persons is empowered by law to give such a judgment. Illustration. A magistrate exercising jurisdiction in respect of a charge on which he has power to sentence to fine or imprisonment with or without appeal is a judge. The corresponding provision is section 19 of the Indian Penal Code. 19. Judge. The word judge denotes not only every person who is officially designated as a judge, but also every person who is empowered by law to give in any legal proceeding, civil or criminal, a definitive judgment or a judgment which, if not appealed against, would be definitive, or a judgment which, if confirmed by some other authority, would be definitive, who is one of a body of persons, which body of persons is empowered by law to give such a judgment. Section 215 says about the term judge. What is meant by judge? In India, there are several persons providing judgment in legal proceedings, but their designation may not be the same. This definition is an inclusive definition. Definitions are of 2 types. One is exclusive definition, other one is inclusive definition. This is an inclusive definition, which means many other things can also be added into this. It's wide. Inclusive definitions are wide, but exclusive definitions are not wide, it is narrow. This definition says anyone who is designated as a judge is a judge, and anyone who is not designated as a judge, but if he provides judgment in a legal proceedings, whatever may be his designation, still he is a judge. For example, magistrate. In a magistrate court, magistrate conducting trial, giving punishment or sentence to the accused, that person is a judge. Though the term is magistrate, he conducts legal proceeding and that magistrate provides judgment, then he is a judge. And judges are also 2 types. One is civil judge, other one is dealing with criminal law. So, in either proceedings, either civil or criminal, if a person dealing with the legal proceedings, then also he is a judge. Civil judges are normally known as munsif or magistrate or civil judge junior division, civil judge junior division, district judge, high court judge, and things like that. So all these persons also come under the definition of judge, though they deal with civil law only. Then the interesting aspect, there can be a group of persons providing verdict. For example, Consumer Protection Commission. That includes several members. One will be the presiding officer, others will be members. So all the members come within the purview of judge. In the High Court and Supreme Court, there is a concept division bench, full bench, larger bench, constitution bench, green bench, and things like that. So if a person is sitting as a single judge, then that person is known as single judge. But if more than one person is there or judge is there, it is known as bench. That is why division bench, larger bench, full bench, constitutional bench, etc. are there. So any member in that group also come within the definition of judge. So as I said earlier, the definition of judge is very wide. It is an inclusive definition. It includes one person and more person or everyone involved in the bench or a group of persons. Can either be civil or criminal, and anyone conducts legal proceedings in which who can provide a definitive judgment is designated as a judge. This particular point must be kept in mind while studying the Bharatiya Nyaya Sanhita. The next definition is section 217, life. Life means the life of a human being unless the contrary appears from the context. The corresponding provision is section 45 of the Indian Penal Code. 45, life. The word life denotes the life of a human being unless the contrary appears from the context. Section 217 of the BNS or 45 of IPC says about the life. Life means the life of a human being. So this is an exclusive definition, not inclusive. Here, life includes only the life of a human being, not of animals. So the word life has got different meaning in common parlance. As far as Bharatiya Nyaya Sanhita is concerned, it is the life of a human being only. This is very important unless the context require otherwise. In the Bharatiya Nyaya Sanhita, we will be studying offences affecting human life, human body. So the term life is very much important. Whatever be the injury caused to the body of a person, whatever be the nature of injury, whatever be the harm or suffering a person suffered, unless his life is taken away, it will not amount to the offense of murder or dowry rape or rash or negligent death. In one incident so happened in United States, a person was beaten up. He was a black and severe injuries were caused to him, undescribable injuries, and for hours together he was tormented, and this created havoc in the entire nation. But finally he was not dead. So in such circumstances, the term life is very much important. Unless that person dies, the offense of murder will not come up. So it can be offense of grievous hurt. And if some acid is used, then it can be termed as acid injury. So injury can be different types. So bodily injury, mental injury, and grievous hurt, simple hurt, etc. But unless the life is taken away, then it will not amount to offense of murder. So the term life means life of a human being unless the term, the context require otherwise. And if life continues, the offense change. If life is taken away, the nature of offense is also changes. So the term life is very much important in the Bharatiya Nyaya Sanhita. Then comes section 220, month and year. Whatever the word month or the word year is used, it is to be understood that the month or the year is to be reckoned according to the Gregorian calendar. The corresponding section is 49 of the Indian Penal Code, 49 of IPC, year or month. Wherever the word year or the word month is used, it is to be understood that the year or the month is to be reckoned according to the British calendar. In this definition, calendar, year, month, etc. are described. In Indian Penal Code, calendar means, or year means, or month means British calendar. That's the word used. So any year in the British calendar, any month in the British calendar is to be understood as year or month. In the Bharatiya Nyaya Sanhita, the term changed British calendar to Gregorian calendar. So anything described as an year in the Gregorian calendar, anything described as a month in the Gregorian calendar is to be understood as year or month. This is the change brought by the Bharatiya Nyaya Sanhita from the Indian Penal Code. But the interesting aspect is that the Britishers follow the Gregorian calendar. So it's only a technical change. Actually, there is no difference. Now we are in 2024, which is according to the Gregorian calendar. There are many other calendars. Malayalam calendar is there, Hijra year is there, and Greek calendar is there. There are many other calendar or calculations regarding the year, month and days are there. But as far as Bharatiya Nyaya Sanhita is concerned, year means year according to Gregorian calendar, which start from AD 1 or Common Era, CE 1, 2, 3. As of now, it is 2024. So months will be January, February, March, April, May, etc., ending by December. So whenever this term year comes, it is only Gregorian calendar. Then Gregorian year must be understood in consonance or in comparison with the financial year. Of course, we understand Malayalam year or Hijra year or some other year or Greek year, we understand the difference. But we may be confused with financial year. Financial year and Gregorian year are two different concepts. Gregorian year starts with January and ends up in December. Whereas a financial year starts from April 1st and ends up in 31st of March. So every financial year will be like this, 23, 24, 2024, 25 and things like that. So 2 years are there. But Gregorian year only one, 2023 or 2024, 2025 and things like that. This we have to understood in comparison with academic year. Academic year starts by June 1st. So every academic year starting from June 1st to next May 31st. This academic year is 2024-25 or 23-24. So academic year starts from June 1st and it will be corresponding into or having contra entry into two different Gregorian years. That is academic year. So academic year, financial year and Gregorian year. All the three are to be understood in three different ways. But in the Indian Penal Code or in the Bharatiya Nyaya Sanhita, British calendar and Gregorian calendar are used. So we have to understand year and month in accordance with this term, starting by January 1st by the end of December 1st in consecutive 12 months, and accordingly we have to understand it. Of course, in the month of February, in every 4 years, there is a leap year, and the days 28 will be just added one more number, 29. So that is known as leap year. So the term leap year also must be understood in this way. That also covered by the Bharatiya Nyaya Sanhita. Every 4 years in rotation, February will have one more day, 29th. So that is known as leap year. So Gregorian calendar, British calendar, academic year, financial year, leap year, all these are to be understood by the students of law or the advocates or judges or even the common public, so that we can understand the year and the month that is used in the statute. Kindly inform me your suggestions and your doubts. I will be answering in the next episode. It will be continued in the next episode also. Until then, thank you.